And I can tell you this is pure evil. What we saw down here today is...
The child has been absent from school without legitimate excuse for the entire 2021-2022 academic year, amounting to an excess of 72 hours, and is thereby a habitual truant. Now picture a manila folder in the Gallia County Juvenile Court, stamped with a single word in red ink: terminated, because the mother could not be found. And now picture 16 children breathing the same stale air in a 12 by 12 room a county away.
It's made up of 4 adults: 73-year-old Gary Ciers Sr., his wife, 67-year-old Christina Ciers, who goes by the name Lynn, their son, 36-year-old Gary Ciers Jr., and his wife, 33-year-old Elizabeth Ciers. On June 30th, a search warrant was executed on their home in Vinton County, Ohio. And that's when investigators found 16 Ciers children ranging in ages from 1 to 18. The state attorney general reported the kids were housed in a 12 by 12 room, emaciated, and allegedly treated worse than livestock. They've all since been charged and face 16 counts each of endangering children. And we're going to break down those charges and bonds, the family's relationship, all of that. But first, a look at rural Vinton County. Here's former Ohio Judge Fanon Rucker.
We have 88 counties in the state of Ohio. Just one state, 88 counties. In fact, Vinton is, I think I read, it's got about 12,000 people, the least populous county out of all 88 in the state of Ohio. It's a largely rural area. As I drive sometimes to Virginia, my alma mater is there. I go through parts of West Virginia. I go through parts of rural Ohio. And it's kind of amazing to me to see how spaced out people are and how disconnected from the rest of the world quite a few people, in fact, I would say the majority of people live versus those who live in urban areas.
This is video straight from Vinton County, Ohio, taken by Law & Crime's very own Anjanette Levy. And we're going to sit down with Anjanette later on in this episode to hear her perspective on the condition of the home and the city. But according to prosecutors, the conditions were absolutely deplorable.
I've been doing these types of cases for a long time. I spent a big portion of my career dedicated to prosecuting these types of cases. And I can tell you this is pure evil. What we saw down here today is pure evil. And I have to commend the deputies from the Vinton County Sheriff's Office and our agents from Ohio BCI and I who went into really kind of one of the worst environments that I've seen in my career, and were there for those children in their time of need.
It's statements like these, the reports of feral children and quote-unquote evil parents, that have made the Ciers family home a new stop in the world of dark tourism. Teresa Kernell drove over 2 hours to get a look at the home.
Just curious about this whole situation, because how could a whole family live like that and no one know it? I wanted to see like how close were neighbors. Usually in small towns, neighbors are friendly with each other, you know, so how would you not know what's going on? And if she was pregnant every year, it looks like somebody would have said, where's all your kids? You know, like, I just don't understand. People usually, you know, especially in a small town, you get excited about when someone's pregnant and you're thinking, oh, did you have your baby? You know, but then you never see it.
While that folder gathered dust. Before we go deeper into what the documents actually show, make sure you're subscribed to Endless Cryme. Because we don't just cover the story, we follow the evidence. That truancy complaint, filed on October 19, 2021, was not about one child. Court records show 6 separate filings against the same parents, 6 of the oldest children, none of whom had stepped inside a classroom that school year.
And that's happening every year, and you never see any children. That's just odd.
Here's what's odd. Somebody did say something. In fact, the courts were even involved. Take a look at this court doc dated October 19th, 2021. Now, this is out of Gallia County, about an hour south of Vinton County, and it's a complaint against parent or guardian for a child being truant. Now, we've blocked out the child's name for their privacy, but here's what the doc reads in part. Quote, the child has been absent from school without legitimate excuse for the entire 2021-2022 academic year to present, an amount in excess of 72 hours for the school year, and as such is thereby a habitual truant. Prior to the filing of this complaint, the undersigned notified said parent or guardian that the said child is not attending school or class in violation of law and required her to cause the said child to attend such school or class forthwith, and the undersigned warned said parent or guardian in writing of the final consequences of truancy if persisted in or of failure to attend such school or class. There's another almost identical court doc for another one of the Ciers kids too, which was also reported as truant. In all, Gary Jr. and Elizabeth Ciers faced 6 truancy complaints. At the time these docs were filed back in fall of 2021, the oldest would have been around 13 years old. Here's former Franklin County prosecutor Ron O'Brien, who specialized in truancy.
I started actually a truancy program, even though you would think a district attorney would not focus on truancy, but I was finding that the people who were 15, 16, and 17, we were binding over for trial as an adult, that their first contact was a truancy charge. Whether it was a robbery, a burglary, or a homicide, their first contact with the court was truancy. And my thought process was, if we can get them into school and get them graduated, that will help both with employment. And I believed correctly that it would prevent them from starting down that road of crime. So you'd have to register in the school district and be assigned to a specific school and then attend. And if they are at least excessively late, tardy, or truant, then there's a truancy officer that is to attempt to contact the parents. And apparently, in trying to contact them, they weren't able to do so, and that's why they filed the complaint.
According to Ron, parents whose children are determined to be habitually truant in the state of Ohio can face fines or even child neglect charges. But by January 2022, just 3 months after those truancy docs were filed, Elizabeth Ciers went missing. This court doc shows the court essentially gave up looking for her and seemingly dropped the truancy investigation. It was filed on January 7th, 2022. It reads, the court finds that Elizabeth Ciers is unable to be served and the whereabouts of Elizabeth Ciers are unknown to the court. Therefore, it is hereby the order of the court that the above matter be terminated until the availability of Elizabeth Ciers.
Usually, the truancy cases we've had over the years are children that are excessively truant, and there's a statutory definition on different levels of absences, but it's somewhat rare to have children not at all going to school, and that's what happened here. And when they learned about it, apparently they filed the complaint in the Gallia County Court, but like any other court document, you have to get service, and they couldn't get service, is what I understand was the problem, number one. And number two, when they did try and find them, they were unable to find them either at different locations. And yesterday, I was given a list of places that the folks had lived at, and they did move around, and those were birth records. For the various children. Some were born in Gallia County, some were born in other parts of Ohio, and they just didn't find a good address for them. And frankly, I don't know how much time and effort they spent in trying to locate them. Obviously,
we have since learned from prosecutors that the Ciers family moved around a lot to multiple different counties in Ohio, even reportedly Wisconsin at one point, and only showed up in Vinton County about 4 years ago. And there are a few things here to start. Is it possible the Ciers family stayed on the move to evade the government?
I think that it happens probably a bit more than we believe, especially when you go from someplace where there is the ability and the finances to monitor and see what's going on, to places where, again, rural areas where people are able to live under the radar. So it does happen, and we do see that from time to time. I don't think it's something that everybody does all the time, but there certainly are instances where people move around in order to avoid the watchful eye of government agencies that may have knocked on their door at some point.
And there's also questions about whether the children were formally taken out of school and then enrolled in homeschooling. But according to Ron, there would be protocol for all of that too.
Of course, there are provisions for homeschooling, but you have to go through a registration process and have it approved by the school district and others that you're going to homeschool the children, and that wasn't done either. Now, mom and dad may claim that they were homeschooling, but you can't just say under Ohio law, I'm homeschooling them. I didn't contact the school district and I didn't register the necessary requirements. So at least it was completely AWOL from the school.
The school district did what Ohio law required. They warned the guardians, they documented the absences, and they turned to the juvenile court. That is Exhibit A, a system that worked on paper. The irony explosion lies in Exhibit B. On January 7, 2022, barely 3 months later, the court terminated every one of those truancy cases with a single finding. Elizabeth Ciers is unable to be served, and the whereabouts of Elizabeth Ciers are unknown to the court. The state's entire mechanism for intervening in the lives of 6 habitually absent children collapsed because a process server could not find a front door. The official record does not mention a follow-up visit to the address on file, no referral to children's services, no flag for law enforcement. The file was simply closed. They just stopped looking. By then, the family had already slid across the county line into Vinton County, one of the least populated and most disconnected corners of Ohio. The move was quiet, no forwarding address.
They were onto him. Well, it appears that in October of 2021, the Gallia County School District, as they are required to do by Ohio law, went to juvenile court and they filed complaints telling Gary Jr. and Elizabeth, 6 of your children who are supposed to be in school have not attended school this entire school year. Now, that entire school year up to that point would have been over a month.
Yeah.
And the school district had warned them and said, look, your kids need to be in school. You're not sending your kids to school. And so they filed this these 6 complaints, and it's for the 6 oldest children. The oldest at that time would have been 13. And they said, your children have not been in school this entire school year. They are habitually truant, and they could be considered or deemed unruly children. And that's just a legal term. Doesn't mean they're out being crazy and doing anything weird. So the courts were getting involved. The school district was doing what they were required to do. The children had missed 72 hours or more of school that year, and that triggers a process whereby they have to go to court and cite the parents for truancy. And there can be fines. There can be child neglect charges that come from that. But they couldn't find the parents to serve them with the paperwork. So then in January of 2022, 3 months later, the court kind of shut down the case because they can't find them. If you can't serve somebody with the paperwork and you can't find somebody, then you can't go through with a process in the courts.
Okay, we feature all of this in our episode too. We go through kind of the truancy paperwork from Gallia County and then the termination of it all, where they say, we literally don't know the whereabouts of Elizabeth Ciers. So we're going to close this for now, whatever. And I mean, you touched on it briefly, but I just want to drill into it a little bit more. We believe that, according to some reports, that they left because of this truancy, like they were running from the law, quote unquote.
Well, I don't know if it's because of the truancy per se.
Okay.
But I have learned that Children's Services, was interested in the Ciers. So they may very well have left before they could even, say the children were truant. Or it could have been Children's Services kind of peeking into this, and then they leave because the kids haven't shown up for school. But it appears around that time, 2020, 2021, somewhere in there, is when they moved to Vinton County. So that is when it appears they moved up there with the kids. And so if you are going to be possibly charged with child neglect because you haven't sent your kids to school, maybe you're like, oh my God, I'm getting out of here. I'm getting out of Dodge.
Yeah.
We got to get out of here with these kids. And that may be what we end up learning when we get.
And yet, this was a household that never once escaped the notice of the state's financial machinery. Secret number 3 sits not in a criminal file but in the databases of Jobs and Family Services. For 18 years, Elizabeth Ciers gave birth at least 17 times, including a set of conjoined twins who died shortly after delivery. Every single birth occurred inside a hospital. Medicaid covered the costs. Food assistance landed on a card each month. IC vouchers were issued. The same government that could not locate a truant child had no trouble locating the family's electronic benefit transfer.
On July 7th, a bond modification request was made in the case of Gary Sr. It reads in part, the defendant in this matter is a 73-year-old man who appears to have some significant health issues, who has very limited mobility, who exhibits concerns for both his mental health and his competency to stand trial, and has no means to post any sort of bond. And I want to note any is underlined, bolded, and italicized. He has no means to post any bond, according to his defense. So a couple of things here. Questions about Gary Sr.'s competency, the lack of funds to meet bond, and of course his age and mobility issues. Now, because of HIPAA laws, we don't know exactly what sort of condition or diagnosis Gary Sr. has, but we do know he took a fall being transported from jail. And we know about all of this because his bond was in fact modified on July 8th. This is straight from the court docs.
The same address that was too obscure for a truancy officer received regular correspondence from the Department of Medicaid. That is not a contradiction. That is a design flaw, one that allowed a house to become invisible in the one system that mattered in hyper, visible in the ones that only required a signature. Now look at the bond modification requests that surfaced after the 4 adults were arrested in late June 2026. The grandfather, a 73-year-old man with severely limited mobility, fell during transport to a preliminary hearing.
Ciers was provided with a bond today, an OR bond. Let me explain the circumstances around that. First, let me stress, the community is not at risk because of this bond. Yesterday, as you all know, the cases were scheduled for preliminary hearing. During the transport, Mr. Ciers fell and had a medical issue that required treatment and assessment. O'Glennis Hospital was where he was taken, and it was determined at that point upon some tests that O'Glennis did that Mr. Ciers Sr. has a serious medical condition that requires specialized care in a hospital outside of this area. Practically, and I don't know if you folks know this or not, but when defendants are housed in county jails, it is the county's responsibility to pay for the medical care. Prisons are for defendants who have been convicted. Then the state pays for it. But he's still an innocent man that has not been convicted yet. So the county was going to be on the hook for his medical care. And again, based on the information that we were provided, his medical care could potentially bankrupt Vinton County. We were not going to put that burden also on our local.
The county jail sent him to a local hospital, and the local hospital transferred him to a larger facility for specialized care. The Vinton County prosecutor, in a public press statement, explained what happened next.
Meanwhile, the fascination with Vinton County and the Ciers family has not slowed down one bit.
I drove by because I was just kind of curious to see actually, because there's so many rumors, you know what I mean, of what's real, what's not, what the cops saw, if they're sensationalizing it, and I really don't think they are, based off of what I've seen. It's horrible, and a lot of people are saying it's a poverty thing, living poor. A lot of people live poor in this area. I don't have money like that, but I don't live like that, you know what I mean? Poverty and dirty are two different things. I mean, the cockroaches, the filth, you don't have to let your kids live like that. So I just kind of wanted to see if I could see from the road myself what it looked like. I mean, obviously you can't see anything from here, but just a lot of concern for them kids. I can't imagine 16 kids in that little house.
And it's all this. Visitors to the crime scene, national news coverage that led Gary Jr.'s defense to petition the court for a gag order, citing allegedly prejudicial statements made by the Attorney General and prosecutors so far. This is straight from the court docs.
Quote, his medical care could potentially bankrupt Vinton County. We were not going to put that burden also on our local taxpayers. So the court modified his bond from a $300,000 in cash surety to a personal recognizance bond with GPS monitoring, paid for by the state. in the event he was released from the hospital. The explicit rationale was fiscal triage. The county balanced its budget against a man facing 16 counts of child endangerment and decided the ledger required him to be free. They just stopped looking. This is the moment the story pivots from neglect to institutional calculus. A single elderly defendant's hospital bill threatened to exhaust a small county's resources. Now ask yourself, if the price of one emergency room visit could have bankrupted Vinton County, what was the price of the silence that preceded it? A single welfare check, a single knock on the door during any of those 16 pregnancies, a single follow-up from Gallia County after the Truancy termination, any of those would have cost nothing. But the machinery of state hummed along, paying bills and closing files, while a 12 by 12 room across town grew more crowded every year. This isn't just a family secret. It's a thriller in which the clock has been ticking for over a decade, and the people paid to hear it were noise, canceling headphones.
And it's all this. Visitors to the crime scene, national news coverage that led Gary Jr.'s defense to petition the court for a gag order, citing allegedly prejudicial statements made by the attorney general and prosecutors so far. This is straight from the court docs. In this case, defendant seeks to invoke the court's duty to protect him from the inherently prejudicial publicity that is currently circulating through comments made by public officials linked to this case. Unfortunately, the Ohio Attorney General's Office, the Vinton County Clerk of Courts, and the Vinton County Sheriff's Office have made statements that make it substantially likely that the defendant's right to a fair trial will be prejudiced. The order cites these specific sound bites.
Most of our livestock was kept in better conditions than the children. It looked like almost feral animals. It was terrible.
Per court docs, these statements have resulted in a substantial probability that the defendant's right to a fair trial will be prejudiced by publicity, and a gag order can prevent further damaging statements. And shockingly, a judge granted this request, writing, "The court finds, given the publicity thus far, that any statements made to media by the Ohio Attorney General's Office, the Vinton County Prosecutor's Office, Vinton County Clerk of Courts, and the Vinton County Sheriff's Office, and any other party related to the investigation of prosecution of the alleged crimes, including defense counsel, would create a reasonable likelihood of prejudicial pretrial publicity, which may impact the ability to impanel an impartial jury. The court finds the following least restrictive and reasonable constraints are necessary."
There is more in the court record, secrets that the defense immediately tried to lock behind a gag order.
The header reads, "Order directing an evaluation to determine whether the defendant is not guilty by reason of insanity and whether the defendant is competent to stand trial." I won't go through the entire document because, honestly, there's a lot to it, but here are the major takeaways for you. First, a certified forensic center designated by the Department of Mental Health has about 30 days to conduct the competency exam. Then the examiner must give their opinion about whether Gary Sr. is competent and explain why. What led them to that belief? What are the facts to prove it? What is the evidence? Now, if Gary Sr. is deemed incompetent, the examiner must also state whether they believe Gary Sr. could ever be competent, and if so, when? What sort of timetable would that look like? So expect movement over the next few weeks in the way of Gary Sr.'s.
The competency examination of the grandfather, ordered within days of his arrest, directs a forensic psychologist to determine whether he was not guilty by reason of insanity and whether he is competent to stand trial.
It is very clear that Elizabeth Ciers cares about these kids. In the hours and hours that I sat there in the jail, she keeps directing the conversation back to, are the kids okay? She's been receiving care packages in the jail, Chris, and today she tried to give me some of the items from her care package to give to the kids.
According to Tommy, Elizabeth maintains her innocence and cares about her kids.
I was able to meet with my client, Elizabeth. I've met with her now 3 times. The person that I met does not come across as pure evil. The person that I met comes across as a mother who has been separated from her children, who is exhausted, and who misses her children, and is asking me constantly what she needs to do to see her children again, what she needs to do to ultimately be reunited with her children. That does not jive with the prosecutor's narrative. It doesn't jive with the attorney general's narrative. And I think because of that language that was used so early on in this case, we are sitting here now having to defend that on television and in the media instead of in a court of law.
The order is boilerplate, but its existence pulls a thread. If the patriarch of a household that allegedly treated children worse than livestock is found incompetent, the criminal culpability splinters. One adult may vanish into a hospital system while the other 3 face the charges. That is secret number 5, the quiet deployment of a mental health defense before any evidence has been tested. Then there is the filing from Elizabeth's brother, posted publicly and quoted in defense motions, in which he asserts that his sister and her husband really did do their best to their IQ allowance, and that low IQ is the one to blame. Her attorney, in a bond modification pleading, did not dispute the characterization. He argued that she had no criminal history, that she was a 33-year-old mother who had been nothing but cooperative, and that she maintained her innocence. Meanwhile, the prosecutor described the home conditions as severe, pervasive intergenerational abuse and neglect. The disconnect is the entire case was this calculated cruelty or catastrophic cognitive limitation.
What does Gary Jr. have to say, if anything? We don't know if he's even spoken to law enforcement, when they first went there. We don't know. But what we do know is that this is not normal. This is not normal. And 15-year-old kids, even if they're pregnant, sorry, I'm just going to say it. You're still a kid. You are a kid. You're a child. And so it raises a lot of questions. When she went to the hospital, were any questions to deliver this baby at age 15? Were any questions asked about, oh my God, how did you get pregnant? That type of thing. Now, by that time, she would have been married. So maybe she's like, hey, I'm an emancipated minor, technically, and I'm married, so it's okay. Who knows? Who knows? But it does beg the question of, were questions asked at the hospital? If you go to the hospital and hospital staff, they're mandatory reporters.
Mandated reporters, yep.
So, and hospitals often employ social workers who get involved when they suspect something might be amiss or awry. And so I'm wondering to myself, did that happen? Did social workers at the hospital come and say, do you guys need some help? You seem to be having a lot of babies. Back to back to back. You're a very young woman.
And if the latter, why did every state agency treat them as fully functional adults when the benefit checks were mailed, but not when the school bell rang? That is secret number 6, the system's selective definition of capacity. The 7th secret is hidden in plain sight inside a marriage license from West Virginia. Elizabeth was 15 years old when she crossed state lines to marry Gary Jr., who was 18. At the time, West Virginia law permitted a child of any age to marry with parental consent. She gave birth for the first time just a few months after the wedding. The legal paperwork from that day never triggered a mandatory reporter's inquiry, never crossed a desk at Child Protective Services, because marriage turned a minor into an emancipated adult. The same documents that celebrated a union erased a child, and that erasure, repeated 16 times in hospital delivery rooms, became the blueprint, paperwork that sees only what it wants to see.